Welcome back to the third and final hour of our conversation with Jeff Sheng. Jeff, just before the break, you were talking about antitrust immunity with respect to open skies agreements, and you made the point that you think the whole open skies series would have occurred irrespective of the existence or otherwise of antitrust immunity. Could you elaborate on that comment?
Well, we were talking about, of course, in the open skies negotiations, giving our trading partners meaningful access to this U.S. market of ours, which is, of course, still the largest and most robust aviation market on the planet. And it seemed to me that if KLM had open access to the U.S. market, and then you imagine Lufthansa might get it, and then have open access to the U.S. market, and then perhaps somebody else would get it, those who didn't have it would soon find themselves very much second-class players in the global industry. So it would, I thought, engender a rush to the top. You would just basically get everybody eventually signing on. The only reason for not doing it would be somehow to continue to regulate aviation. That was what you had the right to do if you didn't want an open skies agreement. You could regulate the capacity of the air transportation that was available to your citizens. You could regulate the price of air transportation to your citizens, which meant keeping airfares higher than the industry itself would have pegged them at. Not a politically popular thing for any government to do. So I don't see what rationale governments would have had in the longer term for trying to maintain the traditional approach. Too many examples would have been out there. It's very much like what happened driving the single market phenomenon. You know, people saw the benefits of deregulation in the U.S. They noticed airfares in Europe were a lot higher per nautical mile than they were in the United States. There's the famous story about the little boy in Berlin who was asked if he knew where New York was on the map. He said, "No, I don't really know where it is, but judging by the airfare to New York versus airfares here, it must be somewhere between Hamburg and London." and that became sort of the story in Europe. They really had to continue to think about liberalizing because there was too much evidence of the good that flowed to consumers and to economies from liberalization to continue to resist it.
But the airlines clearly, as a commercial matter, saw the value of antitrust immunity and the value of code sharing, and somehow they put it all together in the form of the alliance. Would you give them credit for creating the alliance, or was that something that you think the government, I mean, there's been so much government initiative in our discussion today. Where did the initiative come from to build alliances out of code sharing opportunities?
Well, it came from industry. I mean, industry was looking for ways to finally, we presented them with, at long last, a genuine open market. The question then became, well, how do we actually create global entities in a world that's still governed by anachronistic ownership restrictions, that is governed by anachronistic cabotage laws? I mean, we liberalized the bilateral negotiations through open skies, but we didn't change any of these national restrictions. These are all a function of national law, and not just in the U.S., where they're famous, but they're usually those are the laws of just about every country. And so in order to take advantage of this brave new world of global international air transport services, airlines had to be creative about, you know, using open skies agreements, using the ability to forge these alliances in a much more robust way. And to really do that, to in effect manufacture something like a surrogate merger between the two or more airline partners, you had to be free of worry about whether or not you were about to be prosecuted for an antitrust violation, because you weren't allowed to sit down with your alliance partner and talk about the price for air transportation that you should both be charging between a city pair that you were both serving. You shouldn't talk about price at all. Well, if you're forced to be an arm's length competitor of your alliance partner, the alliance really is not going to become a very efficient one. It's not going to become, it won't be throwing off the kinds of consumer benefits that antitrust regulators like to see in these alliances.
But would you agree that open skies is better for the existence of antitrust immunity, that the policy was even more successful because that immunity was made available?
Well, you couldn't have had antitrust immunity without open skies. You needed an open market in order to justify immunizing two competitors in the market. You needed contestability, which would only be available through an open entry policy, and that was what open skies was all about. I think open skies has actually delivered greater benefits by virtue of the antitrust immunity that's been granted to certain alliances and certain players in certain alliances, because at long last we are beginning to see the kind of global competition which otherwise would be impossible. You would continue to have national carriers based in particular countries, governed by the rules of particular countries, flying pursuant to, maybe they're open skies agreements, but they're purely bilateral arrangements. It's a very, very restrictive, at the end of the day, a restrictive, hidebound structure for a business that ought to be as free-flowing and creative as the air transport business. So the antitrust immunity that the industry itself decided it needed, and which government saw value to granting, although the jurisprudence around that morphed over the years in ways we can talk about, I think did deliver much bigger benefits at the end of the day than pure open skies would have delivered.
Well, just to close this topic as we move now to the US-EU and your return to government in 2002, do you think it's ironic, or would you find it ironic, that the liberalization process that we began to talk about this morning began with the revocation of antitrust immunity for the IATA cartel, and the global competition of which you now speak has been made possible by antitrust immunity?
That's an interesting question. Yeah, what the CAB was proposing to revoke was an immunity for price fixing on a global basis.
Yeah.
Open skies and the antitrust immunity that's been granted to alliances has been a pro-competitive development, in my view. It has facilitated meaningful price competition between alliances and giving the participants in these alliances much more strength, if you will, to be robust competitors. It did not, the antitrust immunity we're talking about now is not for the purpose of facilitating a global cartel.
Right.
That was IATA in 1978.
So the irony isn't as deep as I was trying to suggest. Okay.
He hastens to say.
Let's move to your return to government. Why did you come back into the government? How did it happen? 2002, is that correct?
Yeah, I was happily practicing law and not really thinking about going back into government. I thought I had done quite enough of it. Thank you very much. I'd had 20 years or more. And then Norm Mineta became the Secretary of Transportation under George W. Bush. I had known him very well for many years. He'd been the chairman of the Transportation and Infrastructure Committee, the Public Works Committee, chairman of the Aviation Subcommittee. I mean, he'd been doing transportation policy and aviation policy in particular for 25 years in the Congress. I thought he was an amazing choice. He chose as his deputy secretary a fellow named Michael Jackson. Michael had been the chief of staff to Andrew Card, who had been my boss at the very end of the first Bush administration. One day, I received a call from Michael Jackson, who said, "We're thinking about reconfiguring the policy office at the Department of Transportation, and we would like you to come and run the newly configured policy office." And I said, "Thanks very much. I think it's something that ought to be done, but been there, done that. Thank you very much." And that was the end of the conversation. He called me one more time. He actually plied me with drinks for a while. He really, it was all very flattering, but I really felt as though I had done this government thing for long enough. And I knew that my wife was not going to be happy about my going back into government. It had nothing to do with income or salary or anything like that. It just had to do with her knowledge of what government means in terms of your time available to the family and at home, which is exactly right. So I said no again. And then he took no for an answer. And that's when my brain started churning, and I began to think, well, let me think now. That guy, Andrew Card, who had been the Secretary of Transportation, he became the Chief of Staff to George W. Bush. Former Secretary of Transportation is Chief of Staff to the President. Norm Mineta has been doing transportation policy for 25 years, and now he's the Secretary of Transportation. Michael Jackson was a colleague of mine in the first Bush administration, and they want me to help them run the policy shop. This could be the golden age of transportation policy, and I'm basically walking away from that. I didn't feel good about that, and I had a feeling I wasn't going to feel good about it, and so I had a long, heartfelt conversation with my bride, and I said, I really think I want to do this. And she said, well, if you really want to do it, I won't stand in your way, as long as it's not for more than 2 years.
Yeah.
And I said, okay. And I called him back and I said, this was like 4 or 5 weeks after the last conversation. I said, have you given that job to anybody? And at this point I was really nervous that he would have. He said, no, but look, he said, if you're, you got to be serious about this, because I'm not going to go back to the White House and talk about you if you're still toing and froing. I said, if you can manufacture an appointment, I will be there. And so that's what happened.
A presidential appointment.
Yeah, yeah. That they wanted it to be Undersecretary for Policy, but that position didn't exist in the DOT statute. That had to be created, and it took a while to create it because we had 9/11, and Congress was not thinking about moving boxes around on the DOT organizational chart. They were thinking about other things, and so I had a placeholder job for about a year, but then they did create the job, and I became
What sorts of policy and innovations were spinning around in your head? I mean, you said in the first hour, I think, that you'd made a speech to the International Aviation Club a long time ago, proposing a US-EU kind of arrangement.
Wings Club in New York.
Wings Club. In the meantime, you had the Transatlantic Common Aviation Area proposal from the Europeans in 1999 or 2000.
Yeah, well, I was thinking
some
about
of that was still current.
Yeah, no, understand, this was not an aviation-only job. This was a job that involved policy about transportation of all kinds, and I was very concerned about where I knew that the highway program was going, and transit and rail, and I knew that we were really on the cusp of needing some very big innovations in all of that. And as to aviation, I knew that there was a lot of unfinished business, and I knew that there would be pent-up demand for a US-EU agreement, and I thought this would be a way of continuing all of that, and maybe taking it to the logical conclusion, and maybe even finding the wherewithal to change the ownership restrictions such that we could actually, at long last, normalize the legal structure globally for this industry.
Right.
So those were all, in the back of my mind. I mean, ironically, we have to remember that no sooner had I signed up for this job, and long before I got confirmed for it by the Senate, we had 9/11. And the Department of Transportation turned into a security agency.
Yeah.
I mean, all of these vaunted ideas I had about transformations in transportation policy of all kinds were essentially put on the back burner, put on a shelf for 2 years while we created the Transportation Security Administration. It was created at DOT before they created the Department of Homeland Security, and just worried about transportation security in every conceivable way. It was a huge distraction from what I thought was our core job. So we didn't jump right into all of these big issues for a while.
Well, as I understand it, the US-EU negotiations got underway in 2004. Is that correct, with the early harvest approach?
I think that's right.
Where were you at that time? What was your involvement?
Well, as the Undersecretary for Policy, I had 2 assistant secretaries reporting to me. One was an assistant secretary for transportation policy, which meant all the surface programs, and then I had the assistant secretary for aviation and international affairs. And it was in that office that all of the international policy making was done. And so I was basically the godfather of that. I oversaw that, I supervised that.
Who held that
secretary.
position at the time?
Initially it was Reed Vanderwater.
Right.
And then she decided to leave. I think she eventually became a member of the National Mediation Board. And I found a former colleague of mine from one of the law firms I'd worked in, Karan Bhatia, introduced him to Norm Mineta, and in fairly short order, he was then working at the Department of Commerce. He became Reed's successor. He was the assistant secretary for the next several years.
And what was going on in DOT and DOS? Was there collaboration? Was there?
Yes.
Tell us about the way this agreement began to take shape.
Well, I can't, again, being a notch above the working level, I wasn't watching it on a day-to-day basis. I had absolute confidence that both Reed and Karan, after her, would basically figure this out. They knew that I was very interested. I'd been talking about it again for all these years and having a robust conversation with the EU. Along about that time, we had the European Court of Justice deciding that all the open skies bilaterals that we had with our European open skies partners were illegal.
Yes.
Because they failed, because they all had this so-called nationality clause, because they all limited competition in the bilateral markets in question to the national carrier of that European country. And that was, of course, a violation of the very pro-competitive elements of the Treaty of Rome, which envisioned that all European carriers would be able to fly out of Europe from anywhere. Europe had a problem as a result of that decision, and as I recall, they made it abundantly clear very quickly that we had to solve that problem. They had to make these agreements right. They had to conform them, if you will, to the decision of the court. So we took that seriously. It seemed like the perfect opportunity to go to the place I was hoping we would go to in terms of our relationship across the Atlantic. And I think the only cardinal mistake that we made was in saying on day one, well, if we can, work out an open skies agreement, we'll give you that so-called seventh freedom opportunity, as we would call it, the ability of Lufthansa to fly out of Paris and BA to fly out of Rome, and all around.
You came on day one and offered it.
Right. We said, I don't know that I did it, I think it might have been John Byerly, who was, I believe, the Deputy Assistant Secretary at the time, but this was all discussed. We basically wanted them to know. I may have said it in one of my speeches. We understand the value of this to Europe. We understand the importance of living up to the Treaty of Rome. This has been our vision as well. We have longed for a more robust and open textured relationship with Europe in aviation. This may be just the ticket, just the opportunity that we've been looking for. And so you can be sure if we finally get to an agreement that makes sense in all of its dimensions, that this so-called seventh freedom opportunity that's lacking in the open skies agreements, the thing that the European Court of Justice focused on, we would solve that problem.
Did you think this was going to be an impossible task? 27 countries negotiating with the United States at the same time.
No, I mean, I thought they had every reason to negotiate with us. It was going to be the U.S. that was, after all, taking the big hit, and that theoretically that was, I mean, if you just take the U.S.-German agreement, a lot of U.S. carriers can fly to Germany under the agreement, but for all intents and purposes, it was Lufthansa coming out of Germany. Now, if we were going to sign this open skies agreement with the EU as opposed to just Germany, all of the European carriers could fly out of Frankfurt or Munich, or So it seemed as though we were the ones that were going to have to make the decision. The Europeans, basically already faced this multiplicity of U.S. carriers. I didn't see that they were going to have to face very big decision-making of any kind. It was we that would have to do it, and I knew that we were prepared to do it in the interest of having this agreement.
And you felt you had the authority to make this open gesture at the very beginning, that you would recognize the seventh freedom. Where did that authority come from?
Where did the authority come from? Well, these agreements are executive agreements. The statutes aren't so granular as to prescribe the limits on our negotiators and what they can do. So yeah,
once again, IATCA was not going to be a handicap.
We had broken the back of IATCA in the open skies agreements. That was no longer an issue. The issue really was politics. Would there be any real likelihood that we would see a proliferation of European carriers coming out of Paris or London or anywhere else? And we thought probably not. They probably aren't going to challenge each other too much.
Yeah.
So it seemed, I thought, in my naive way, it would be pretty easy.
Why was that naive?
I forgot about the UK. British Airways perceived itself, with some justification, as the single airline that was going to pay the price for this big new agreement. Again, the U.S. had open skies agreements with everybody else. U.S. carriers had their way with everybody else. They could fly anywhere they wanted and through, except Heathrow. Heathrow, being part of the EU, last time we checked, would be opened up as part of any bilateral, any open skies agreement that we did with Europe. That meant that BA would suddenly face a whole different quality of competition at its hub. And it was difficult because the UK, as you pointed out, is a market-based economy. It's a market-based government. They believe in competition. They're very consumer-oriented in their own domestic regulation. The UK couldn't just say, we don't want open skies. I mean, that would have been anathema. So they decided to say, we want true open skies. And by true open skies, they meant it's not enough to simply open up our gateways and have more people flying. We really need to have a free flow of capital between countries. We need to have the wherewithal, if we choose, to buy a U.S. carrier and operate within the United States. Any European carrier that wants to play in that market should have the ability to do so. And if a U.S. carrier wants to come and do the same thing in Europe, it should have the ability to do so as well. I mean, it was a beautiful concept. It made every bit of economic sense. That is exactly what the industry should look like. And it was, as B.A. well understood, politically impossible to accomplish.
Did they wrap cabotage rights into that demand?
I can't recall. They didn't need to.
Didn't need to.
I think they probably, thought that that would be a natural part of it, because they would have said, and the Europeans generally said, the U.S. was enjoying cabotage rights in Europe, as we were, through Fifth Freedom rights. They were doing it through code sharing at this point, not actually flying between these cities. But the fact is that that was another lopsided element of the transatlantic marketplace.
So how did you respond to the British, the negotiations terminated on that point and then resumed again? But
well,
at some point you had your notice of proposed rulemaking.
Yeah, it was during the first effort to try to forge the agreement. Again, I was not unsympathetic to what the UK was asking for, and I thought, well, maybe this is precisely the impetus that we need. We can finally get these restrictions cleaned off the books. But I knew that if Congress had to vote on it, it would never happen. I mean, there was just too much deep-seated opposition, particularly within the labor unions, but even the airlines. If the airlines weren't going to be campaigning for it in a robust way, Congress was never going to make the change. And the airlines would not campaign for it because they had enough problems with labor. They were fighting enough battles with the unions on enough different fronts that adding this one, having a battle with the unions over whether or not we should liberalize the foreign investment restrictions, who needed that? I mean, it really wasn't going to make much of a difference, they felt. So I thought the politics just weren't, the stars were not lined up to make any statutory change. As I recall, Karan Bhatia came to me after thinking deeply about this for a long time, very creative guy. And he said, I think there's a way we could do this administratively without reference to Congress. And he described to me a way of, remember, the serious restriction on foreign investment is not the statutory 25% limit. That, people can live with that. We would allow preferred shares, non-voting shares in excess of the 25% limit. We've had circumstances where foreign investors have had more than half the equity of a U.S. carrier, but only 25% of the voting.
Right.
He said, well, what if we, and the restriction was there couldn't be any semblance of control. Whatever ownership you had of the carrier, you couldn't exercise control. That was a construct of the CAB. That was a purely a common law rule, if you will, that came out of CAB cases over many, many years. It wasn't written down anywhere. So he said, what if we very deliberately, through a notice of proposed rulemaking or through a decision that people can comment on, decided to redefine control.
But it was in the statute at this point. The 2002 amendment put the words actual control into the statute.
Control was in the statute.
Yeah, not previously, but after 2002.
No. Control was in the statute previously.
Was it? Okay.
Yeah. It wasn't actual control.
Okay.
But we knew that was the predicate for the CAB's decision that no semblance of control could be exercised by a foreign carrier. They had taken the notion that foreigners couldn't control an airline, which was just a fairly wooden, brief statement in the definition of a U.S. citizen, I think, in the statute. And the CAB over the years said that really no semblance of control. I mean, it was, they made it as strict as possible. Any suggestion that you are touching a hair on the head of this U.S. carrier and you're content, if you have a foreign passport, that's illegal. Karan said, and I was intrigued with this notion, we can redefine that. It was done by the CAB. It was manufactured out of whole cloth back in the 40s or 50s or whenever. We could redo that. We could say what we mean by control is control of those elements of an airline operation in which the government has some equity. Decisions about safety, decisions about participation in national defense programs. Those are the kinds of decisions. National security, what kind of security program does it, things that the government cares about. Why should the government care if some foreign entity is controlling a decision about flight attendant uniforms, routes to be flown, frequencies to be flown, whether to raise fares or lower? I mean, why would we care? Those are wholly commercial aspects of an airline operation, and the government has no stake in any of that. And we've said that over and over again in all of the stuff that we've been putting out in terms of deregulation, open skies, and what have you. So the idea was to put out a notice of proposed rulemaking, basically saying all of that and asking for comment on it. Henceforth, we propose to evaluate the control that is prohibited by the statute as control over these equities that are of interest to government: safety, security, national defense. We put that out, got a raft of comments back, many of them intrigued and positive. And of course, the Europeans were watching it very closely. At one point, they felt that it might be a pig in a poke, that there really wasn't very much there. This was just a bit of fluff that we were trying to show them to demonstrate that we could deliver this.
Why did you find that idea appealing when Karan brought it to you?
Well, I may have forgotten the first step of the story, which is the Europeans, of course, had put this on the table as a result of the UK's insistence.
Right.
So it became part of that negotiation.
Mm-hmm.
And that was the reason why we decided to try to be creative about it.
Mm-hmm.
Again, I was intrigued that we actually had an opportunity to do something about this rule, which I had felt was an anachronism for a long, long time.
Mm-hmm.
We didn't want it to be, I mean, it was going to be politically difficult to be seen as doing it solely to satisfy the European Commission in these negotiations. We had genuine reasons for wanting to do it ourselves, and in fact, I said many times that if the negotiations dried up and went away tomorrow, we would continue to follow this rule through, because there was a genuine interest in our government in seeing whether we could liberalize the foreign ownership restrictions to that extent. In any event, we put the rule out, we got comments on it. When the Congress really began thinking that this actually was going to be done, that the Department of Transportation was serious about this, I think it was Chairman of the Aviation Subcommittee, Jim Oberstar, who had such a long and respected reputation in Congress for all of his work in transportation that they sort of treated him as Mr. Transportation and specifically Mr. Aviation. He was adamantly opposed to this.
You testified before him.
Yes, I testified.
According to John Barley, you took the larger arrows and slings and spears. Do you remember that?
Would you like to see my scars?
Well,
yeah.
Is that an accurate statement?
Oh, absolutely. Yeah. No, I did, and I basically put it all on the table and got a real shellacking from members of Congress for having said it. But again, we weren't proposing to do anything that the Congress was going to have any say over. So I was essentially there to describe it for them, being polite. But I thought this was something well within our power to do. What Chairman Oberstar managed to do, however, was collect pledges from about 3/4 of the House of Representatives that the moment we did it, they would pass a bill that would legislative repeal what we had done, and in effect make the anachronisms even worse. And that was a pretty serious threat, and we took our measure of that. The White House got involved. The White House was obviously enthusiastic about trying to make this step forward. We had a lot of support from the Domestic Policy Council for doing it. This was now the George W. Bush administration. But when they realized that the likelihood was we were going to get a great big pie in the face from Congress, that they would actually repeal it on day one through an act of Congress, we began to think that this might just be beyond reach.
Was there a threat of withholding appropriations to support the interpretation of the rule? I
don't think it ever got to that,
Never
honestly.
got to that. Why didn't you bypass the NPRM proceeding and just adopt the rule?
Couldn't. You couldn't under U.S. law. If you've got a policy that's been in place, enshrined in so many cases, that has been acknowledged, that the industry has relied upon in all of its own decision-making, you have to morph out of that. You have to segue out of that in a very deliberate way. As a matter of administrative law in the U.S., you can't just change your mind.
Even with the Chevron doctrine protection?
My view is that you really have to do it deliberately.
Because you got some pushback from the private bar, for example. There were suggestions that it could have been done by fiat and that there was no need for the NPRM.
It's possible. Mm-hmm. I think it would have been even more offensive. But what's absolutely clear, what happened, even doing it as deliberately and as I thought politely and respectfully as we did, giving everybody who had a view on it an opportunity to tell us what they thought before we did it, it's pretty, and we still got that threat of repeal that was, absolutely I mean, it was going to be a success. We would have lost. There was no question about that. If we had done it in the way you're suggesting, with just by fiat, it would have happened even faster, and probably the consequences would have been worse.
But after all your prior experience in your previous time in government, where you never had these kinds of issues, Congress and you never clashed on any particular innovation that you were creating, this must have been quite a difficult experience for you.
Well, it wasn't. No, I was used to clashing with Congress on any number of things. Remember, again, during those famous Levitas hearings that I talked about in the late 70s and early 80s, there was a huge amount of pushback. Now, I wasn't central to it at that point. I was a lawyer who was kind of on the delegation, but I was watching very closely as the administration took a huge hit from Congress for being audacious enough to go out and give away hard rights for soft rights.
Yeah.
I had seen that. The cities program was controversial. I've been taken to task any number of times for any number of specific negotiations that, or specific agreements that we'd done where a concession was made and perceived to be too rich for the agreement.
But with this kind of high profile, this was
nothing with a.
This was unusually high profile.
Yeah.
Dubai Ports was in the background, wasn't it, as well? That
Dubai
issue.
Ports came along in the middle of all of this. Yes, and I remember Dubai Ports.
Explain what that is.
Well, Dubai Ports was an episode in which a Dubai Ports World, a Dubai-based operator of ports globally, wanted to buy 6 or 8 port operations in the United States. In order to do that, and this wasn't subject, of course, to the aviation restrictions, there was no ab initio a priori restriction on foreign ownership of ports in the United States. In fact, the ports which Dubai Ports World wanted to buy were already owned by a British firm. So that wasn't the problem, but they had to go through what we call the CFIUS process, the Committee on Foreign Investment in the United States. And that's just to review the security dimensions of the investment. And we do that with every major foreign investment that's deemed to have any strategic significance. That came across my desk. I signed it. I don't think it stayed on my desk for more than a minute. The recommendation came, no security issue. Every other cabinet department had exactly the same presentation. Every other cabinet department in the Bush administration had no problem with it. It went through the CFIUS process like a knife through butter, as they say, and we approved it. And then politics happened. There was an opportunity to embarrass the Bush administration by virtue of the fact that it was actually going to allow this Arab company to buy all of these ports. What did that say? I mean, I frankly thought I thought the United States had lost its collective mind. Dubai Ports World was so large a company that they were already loading all of the vessels that they were now proposing to unload in the U.S. If we're really worried about the security of Dubai Ports World, we don't need to worry about buying U.S. ports. They're already out there loading these vessels that are coming to our country. Why have we not been concerned about that? We weren't concerned about it because they were a world-class port operator. It became an iconic, a very embarrassing episode for the United States, and it came exactly, as you suggest, at the worst possible time in terms of our deliberations over foreign investment in U.S.
Was it explicitly connected to your
The connection was certainly made by the opponents. It simply, well, I don't think, if we hadn't had Dubai Ports World, I think we would have still ended up the same way. I don't think we could have done the NPR. I don't think we could have finalized it and succeeded in the way we were hoping to, just by virtue of the fact that it had become so controversial. There was really a lot of demagoguing going on about what would happen to U.S. airlines, what would happen to labor, who would be doing all the flying. A real villainization, I think, of the foreign owners. None of it made any sense to me. I should have been a little bit smarter in anticipating it. I had briefed all of the Europeans were skeptical that there'd be anything there, and I briefed them and I explained how much would be there. And then I felt that because they were reading the transcript of hearings before Congress, when Congress asked me what this all meant, I had to say, yes, a foreign manager would be able to do anything with a U.S. airline that it wanted as long as it was wholly confined to commercial considerations, not national security, national defense, or safety. I actually saw a clip of some of that testimony on Lou Dobbs. Do you remember Lou Dobbs when he was out there being as jingoistic as possible.
Yes, he took the Dubai ports issue for himself.
Well, yeah, and immigration and everything
Yeah.
else. And so this thing was really hyped to the max, as
Yeah.
we say, and it just became impossible. Became impossible to do. I was deeply disappointed, again, not because of what it implied for the US-EU negotiations. My conviction was the EU really needed these negotiations.
Mhm.
It really needed this Open Skies Agreement
Yeah.
for reasons having to do with the European Court of Justice and that decision. So we were going to get that one way or another, but I was really, really hoping we could leverage that negotiation in a way that enabled us to get rid of some of these anachronisms in our own law, and really devastated that
Do
we
you
lost
really
that
think,
opportunity.
counterfactually, do you think if it had been adopted, the NPRM, that kind of structure would have worked in an American airline, where you had the separation between what government's interested in and the daily commercial activities? I mean, did you ever sort of
I think it would have
experiment with it?
First of all, what was the rationale for suggesting that U.S. citizens had to be in charge of safety and not foreign citizens? Are foreign citizens cavalier about safety in the air transport business? My view was this was our foot in the door. This was how to define it and justify it and defend it, and that eventually somebody would snap out of it and realize, why are we making this distinction? Let's just normalize this industry once and for all. So it seemed to me a temporary exigency.
What happened? Did you decide to pull the NPRM?
No, it was. I can remember exactly. We we had a meeting at the White House, not with the president, but with the president's advisors, and it was a robust conversation. There were, again, White House advisors to the president who were adamant that we not pull the plug,
Really?
more strenuously than even the Department of Transportation. I mean, this was, in a sense, it was a political issue for the White House. We were just serving up the content, but at the end of the day, it had to be a decision the White House made, and it was simply the view, and I think that it was an absolutely correct view. We could not win this. This would just be a legislative defeat for the administration, and who needs it? It was a brand new Congress, and it was a brand new legislative cycle, and it was a perfectly rational decision, it seemed to me, to pull the plug on the NPRM, which meant, of course, going back to the US-EU negotiations, having
Yes.
to recalibrate all of the assumptions about that. And this became extremely difficult. The UK had said that it was a sine qua non to their signing on. The UK being sufficiently important within the EU complex that without a UK agreement, it was going to be very difficult for the people in Brussels to deliver that agreement. So it was a huge problem.
And did you stay involved in the negotiations to the end?
Oh yeah, sure. I mean, I stayed involved as if you will, a supervisor, an overseer. I got daily reports on those negotiations and contributed a lot of, interim decisions along the way as we try to figure out which turns to take.
We have discussed the course of those negotiations with John Byerley, but I wonder how you feel overall about the outcome. Do you think the European Union was disappointed? Do you think that the United States was pleased? The Heathrow was released into the open skies world?
Well, the United States was certainly pleased with the agreement to the extent that we got it. I mean, I think and maybe I have to say, I may be speaking more personally than on behalf of the U.S. government, because I'm not really authorized to represent the U.S. government any longer. But I would say to the EU was clearly disappointed that we didn't make that huge leap forward that they had made a part and parcel, thanks to the UK, of their negotiating requirement. But, and this isn't widely understood, I think the United States was disappointed in precisely the same way. That we had hoped that the negotiation would produce breakthroughs even within our domestic law, particularly to normalize this industry at long last, such that we could really let the industry seek its own level as an economic proposition. It continues to be highly artificial in its structure, and the antitrust immunity and the alliances, of course, are a well-understood surrogate, for the kinds of mixing and matching and ferment that you might have seen in a more normalized industry, one that didn't have these rules. I'm very disappointed that we just don't know yet what this industry is capable of in terms of delivering the real service to
Right.
populations around the world.
But going back before we close our discussion of US-EU to when you met with with Karen, I think you said, to discuss the interpretation of the term actual control, once again you were in a position where you were able to take a broad view of a piece of text, and you were able to run with that as a government matter, as a policy matter, because you thought that was good public policy. I mean, that seems to have been a theme in the way in which you have approached your career, that you have looked at these texts in a flexible way. And that indeed pushed a lot of the evolution of international aviation policy in your first period. So to what extent do you feel that the NPRM experience in effect closed some of your flexibility, or did you feel that at all through this process?
I wouldn't draw that large a conclusion. That was an issue that had been singled out by the AFL-CIO as the most important issue in transportation for the year. I mean, this was not just another issue. This wasn't a challenge to the ability of the administration or any executive branch department to interpret statutes. That's unquestioned. It was that we had chosen to interpret a particular policy that had been on the books a long, long time, that huge numbers of stakeholders felt very comfortable with, and turn it on its head, and do it through an NPRM process. Because, you know, we have to understand as we look at liberalization that, in fairness, deregulation flowed huge economic benefits to consumers, and those have been measured in a number of economic studies, and we all know about those. But it's also fair to say that labor didn't do very well as a result. Suddenly there was downward pressure on rates. That meant there'd be downward pressure on wages. An industry that people would go into because of its glamour, because of the excitement of world travel, because of the comfort people had that it was a regulated industry, and you could be pretty comfortable where you would end up, suddenly was turned inside out. Careers were destroyed. The unions that organized airline workers saw nothing good in the deregulation process. Here we were proposing to liberalize it yet again in ways that were untested, that suggested now we would have offshore owners, people managing airlines that we didn't even know, and the mythology was out there that they wouldn't even have to comply with U.S. labor laws, which was of course completely untrue, but that was the word that went out. I'm not the least bit surprised that labor continues to look with real skepticism at another major change, the dimensions of which they don't fully understand. It seemed to me understandable, and we probably should have appreciated to a greater extent what it meant. We also had the Department of Defense to worry about. Remember that the Department of Defense was, always assumed to be adamantly opposed to any liberalization of these rules. Well, it goes without saying, I couldn't have proposed an NPRM or anything else that would have affected foreign ownership rules in any way without being comfortable that the Department of Defense was comfortable with it. I had worked for many years, even during my private sector time, with the Military Airlift Command based out in St. Louis, and I was chairman of something called the Military Airlift Committee. It was sort of a pro bono thing. And I knew the commanders-in-chief of the Air Mobility Command and the U.S. Transportation Command very well, and those relationships were valuable when I was able to present this NPRM to them and to quantify for them the extent to which it would not have any negative impact on their access to the airlift upon which the commercial, civilian airlift upon which they depend for a lot of peacetime movements and even wartime movements. They were completely comfortable with it. I thought I had I won't go so far as to say I thought I had agreement from the unions, but I certainly spent time with them trying to talk them through it and trying to get them to understand that they were entirely protected here. There wasn't going to be any giving up on U.S. labor law, that whatever protections they had under the current system, they would have under the new system. What they would also have is a lot more capital in their companies and make them more successful, and there would be more jobs, but that didn't seem to...
And didn't Congressman Oberstar respond with another bill in which he actually made it a condition of employment as an executive in a U.S. airline that that person be a citizen of the United States?
Yeah.
So
A bill, I'm happy to say, went nowhere.
Went nowhere, but it was part of that, the fallout from the NPRM, I suppose.
I suppose.
One other question about the US-EU agreement. Did it ever occur to you, because you really wanted to remake the world with this agreement, to some extent anyway,
Yeah.
to use an Article 2 treaty as the methodology for getting it through Congress and not an executive agreement?
No.
Was that ever discussed?
No. The last thing in the world we needed was a battle over ratification in the Congress. That's the nice thing about, and all of the progress that we made, I think, in moving from the Bermuda One model to the Open Skies model, I think is largely attributable to the fact that we define these agreements as executive agreements in our system, which is to say, under the CASE Act, we notify the House of Representatives, we've done this agreement, but we don't ask anybody's permission. Better to ask forgiveness than permission. And to have to go back to Congress with a brand new Open Skies model and say, let's ratify this new treaty that we have with the Netherlands, with people like Bob Crandall screaming that he was going to fire 5,000 people off to the side, I think it would have been impossible.
Over the years, did you ever reflect on the fact that the executive agreement was an interesting way to create these treaties, that Congress was never directly involved?
Well, Congress should be involved in a lot less, it seems to me, that they're involved in. It's just dumb luck, I think, that they chose this route. I think it was because for the longest time, these agreements were not particularly interesting.
Yeah.
They were adding one more gateway. It wasn't the stuff of Congress, you know. When it suddenly morphed into something far more interesting and intriguing and liberalizing, changing all the assumptions that an industry had been relying upon for a long time, I would argue that that probably was something Congress might have focused on, and you could justify having a treaty ratification process, but luckily we had already established the executive agreement pattern and we were able to stay within it. We still had lots of hearings. I mean, the Congress maintained oversight.
Yeah.
Chose to leave us to our own devices, I'm happy to say.
But you maintained an interest in this question of foreign ownership even after you left public service.
Yes.
What about the IATA, Agenda for Freedom?
Well, this was a remarkable episode. I'm not used to seeing associations of airlines actually advocating forms of liberalization that even their members do not necessarily subscribe to. Under the leadership of Giovanni Bisognani, IATA, still the global association for the airline industry, decided that one of the real impediments to making money in this business continues to be a set of anachronistic restrictions that individual governments put on the industry. I mean, he would have also said there's too much taxation and, you know, all the usual arguments, but he was focused quite miraculously for this purpose on the restrictions that governments put on ownership of airlines, not through their national laws, but through bilateral agreements. And what he was talking about in the first instance was the nationality clause. And just to explain that in words of one syllable for a moment, in a bilateral agreement, the agreement says each party has the ability to say no to an airline from the other side if it's not satisfied that that airline who wants to serve its territory is owned and controlled by nationals of that country. So what that means is that these bilateral aviation agreements give each party the ability to control the legislative process in the other party. You may not liberalize your ownership rules, even for your own purposes, because if you do, I won't let your airlines fly to my country.
Right.
And I have the right to do that under the bilateral agreement. Giovanni's view was, that's nuts. Countries should be allowed to do what they want, as long as an airline was based in the other country and was a creature of the other country, regardless of its ownership, regardless of where its headquarters might be, it should be allowed to fly. And so he created the Agenda for Freedom. We found a group of like-minded CAAs that were sympathetic to this notion. We gathered them at a meeting in Istanbul in 2008 or 9, 2009 I think it was. And we began talking about not a treaty, but sort of a joint understanding, a mutual pact in which they would agree, just as a matter of trust, that they wouldn't exercise these restrictions even though they could.
On a reciprocal basis, I see.
On a reciprocal basis, of course, but you know, looking at their own interests the entire time. We had a second meeting in Montebello, just outside of Montreal, and in fact that joint statement was signed by about 5 or 6 or 7 governments. Not governments, but the CAAs. Again, it wasn't at the governmental level, but it was an understanding among regulators.
And you presided at that event.
I presided at both events. He asked me to chair the agenda for freedom, which I did and which I was privileged to do. I thought it was innovative. I thought it was forward-looking. I thought it spoke very highly of IATA. This erstwhile cartel, that had been the subject of the show cause proceeding in 1978, had now actually begun getting ahead of where governments were in terms of its vision of what a liberal market could look like. It was spectacular. I just thought it challenged government thinking in ways that I'd never seen the industry do before. A far cry from the reactions to the cities program, or reactions to even the Carter administration's liberalization. It really was a sea change, I think, in the way the industry was looking at this whole issue. It meant for me, among other things, that the industry had embraced liberalization at long last, and now was impatient to see, the other shoe drop.
And to push governments,
Let's let's push governments to the point where they get out of our way completely.
And what happened to it?
It stopped. I think that as a result, this is my surmise. I can't say this. I don't know this on a first-hand basis, but we saw some very powerful airlines emerging from parts of the Middle East. And they were putting together a very, very attractive service, a level of service that unmatched anywhere. And because of their geographic location, were becoming the new KLMs, to make your point.
Come back to that point, yes.
The ultimate six freedom carriers,
right,
carrying people from the west to the east, over Dubai, over Abu Dhabi. A huge challenge to the traditional carriers, and my guess is, because the Agenda for Freedom stopped dead in its tracks, we never took it any further, that IATA's membership went to management and said, if you keep pushing this, we're going to lose our ability to keep a damper on what these Leviathan airlines are beginning to do to us in our own markets. We don't want this Agenda for Freedom to go very much further. Thank you. And so IATA essentially just stopped it. It is what it is. I mean,
an interesting experiment in quasi-international lawmaking, I suppose.
And I think that it will ultimately prove to have succeeded, in the sense that I really find, as people continue to liberalize, and they will, it's just a natural course of events, as airlines become multinational creatures over time, it's going to be unseemly for a government to raise an objection to the ownership of somebody else's airline, even though the bilateral agreement might technically give you the ability to do so.
And if Willie Walsh tries to buy American Airlines, maybe we'll see some from the ground up changes in the way governments perceive these rules.
Yeah, it's going to be interesting to watch that development, to see if that actually happens, because that will be a very interesting problem for the U.S. to have to wrestle with.
Jeff, I have several hours of questions for you, and I'm down to the less than 10 minutes. I do want to talk about ICAO for a few minutes, since you presided over ICAO, the International Civil Aviation Organization. What's your impression of that organization? It's in the crosshairs now with the emissions trading system controversy.
Well, two impressions. One is it's a superb organization, I think. It's I worked for the United Nations for a while, and I know something about some of the UN agencies that are out there. ICAO, I think, stands head and shoulders over others, and I know I'll be criticized for this by the World Health Organization, but I think they deliver enormous value to the member states through their management of the global framework for international air transport. That's the secretariat that I'm talking about, their ability to deliver what the member states need. Where ICAO becomes more problematic is where the member states have to vote on things, because they all have one vote each. They are in the crosshairs at the moment because of the controversy over the European emission trading scheme. Everybody who's not a European, and even some people who are Europeans, seem to be against what the EU is doing. ICAO should be the locus of the activity that delivers the quality of emissions control reduction over time that ends up satisfying the European Commission's requirements. And that would give the European Commission a graceful way out of applying the ETS unilaterally to foreign carriers flying to and from Europe. The problem that ICAO has is that the only way it can do that is by getting its member states to adopt something. We tried to do this in 2007 when I was president of that assembly. we pulled together a small group. That's the only way business gets done, with a small group. It involved all of the major players, including the Chinese and India. And what I found was that as a result of concepts that were first articulated in Kyoto, concepts like common but differentiated responsibilities, which is an elaborate way of saying if you are a developing economy, you can get a pass on whatever the rest of the world does in the sphere of emissions trading. Because of that concept, they were unwilling to really make any kind of move. They were unwilling to participate in any agreement that would have moved in the direction of satisfying Europe. I was unable during the assembly, the 36th assembly in 2007, to make any progress on that. We did a resolution which said you shouldn't do things unilaterally, and market-based measures are a good thing, and indeed what the Europeans are doing might make sense as a global system, but nobody should impose their own system on foreign airlines without mutual agreement. That's what the resolution said. The Europeans have been very clear that if the world comes up with a way of achieving what it is that the Europeans are trying to achieve through the ETS, they will back down. That's what they say out loud all the time at every conference they go to. Can ICAO manufacture that excuse for allowing the Europeans to back down? Thus far, the answer has been no, and I saw that close up and personal. I am not giving up on ICAO, however, because I think the pressures are huge, and they're mounting. It may well be that ICAO will find a way to concoct a formula whereby there will be measured reductions, measured targets that have to be achieved by governments and by their airlines, by the industry over time, and that can be characterized as precisely what the Europeans were trying to achieve through the ETS. And maybe that can be the way out. If it's not that, I have a feeling it's going to be an Article 84 proceeding before ICAO. And,
which ICAO isn't particularly well equipped to deal with.
Right. I mean, it will be an unhappy development for sure, and it's not likely to produce a result that satisfies anybody at the end of the day. So I think we really need to be optimistic that ICAO, having now gone through several rounds of failure to come together around a scheme, will finally begin to deliver.
Well, maybe this ICAO experience will be one of your answers to my final question, or close to my final question. Looking back on your long career in government service and your central role in U.S. national and international aviation policy, what do you think was your greatest achievement and what was your greatest disappointment?
Well, the answer might surprise you. I think of the greatest achievement, if you will, and then that engendered the wherewithal to do the things that we've been talking about, was just survival. just having either chosen or simply decided not to choose what my career would be for enough years that I was eventually empowered to see what John Byerly very kindly called the forest instead of the trees.
Yeah.
You don't, so many, there have been so many brilliant people that have come through the process, and I've worked with all of them, and most of them come in political appointments, and they stay for 2 years, and they do a marvelous job for 2 years, and then they leave. 2 years, unfortunately, is not enough time to achieve anything. You can push the envelope a little bit, you can push things in the right direction, but then you leave. Mm-hmm. To really make something important happen, there's got to be continuity of leadership. And I think if I've done anything right in this business, it's just staying there long enough or coming back frequently enough to continue to move things in the direction which I think they would have moved anyway. I mean, I want to be very clear about this. And good in government, if you can move something in a direction that it's already moving and get it there 5 minutes ahead of time, you've had a good day. And I think much of my career could be defined that way.
I think in that sense, your greatest achievement may have been that you could hand a memo to the Secretary of Transportation, he could write, "Go for it," on the memo. That was pretty impressive.
Well, yeah, but I think what was impressive was that he would do that, notwithstanding the fact that I'd been around for many years.
Your greatest disappointment?
That we are still stuck in an anachronistic world, that we haven't begun to unleash the real power of air transportation for the benefit of national economies everywhere and for the global economy. I mean, I look at this industry and I think, what would it look like if we didn't have these completely bizarre and unique restrictions on their corporate existence? And the industry itself is increasingly strange to me, and I don't mind saying this on the record, and I'm going to go to Istanbul at a conference next week and probably say it out loud there. This is a service industry, and maybe this is a US-centric view, I'm not really sure, but it seems to me this is the only service industry I've ever seen which has declared war on its customers, on its distributors, and on its regulators. And I'm trying to understand, what exactly is the strategy designed to achieve? How can this industry actually become something that people are attracted to, as opposed to treating as a necessary evil?
Jeff, with those tantalizing remarks, we come to the end of our 3 hours, and we close this installment
5 minutes sooner.
We close this installment of Conversations with Aviation Leaders. Sincere thanks, of course, to you for generously giving us your time to join us today in Chicago, and for your immense contribution to the advancement of so many aspects of domestic and global aviation policy. You certainly have demonstrated today not only that you see the forest and can work with the trees as well, but that you have shown how important government can be in forming and fashioning and creating policy. It's been a fascinating insight into something that we don't often appreciate. In fact, we rarely get to see. And we at the Institute are honored that you gave us the opportunity today to archive many of your thoughts and reminiscences about your long and productive career, and we wish you continued success. And you've also offered very kindly, as we discussed at dinner last night, to allow us to archive and to digitize the remarkable product of your, what did you call it, your backpacking, your packing all those documents together over so many years that you assembled, and we will post details of that special collection on our website very soon.
Marvelous.
So thank you again, Jeff, and goodbye from the International Aviation Law Institute in Chicago.
Thank you.
Thank you so much.